Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, a recent judgment has passed by this Honorable Supreme Court of India, in which civil appeal number of 2023 arises from special leave petition number civil 3543 of 2019. It's a reportable judgment in which there is an appellant versus the Maharashtra State Electricity Distribution Company Limited and others. So, in the nutshell, we can this judgment speaks about the ex parte order which was set aside by the trial court itself, and the respondents thereafter filed a writ petition before this Honorable High Court of Bombay. The Honorable High Court has set aside the order which has allowed the application for setting aside the ex parte order. It means the decree was restored. Finally, the appellant had agreed from that order and then filed a special leave petition before the Honorable Supreme Court of India. So in this judgment, we will see that Order 9, Rule 13 of the Civil Procedure Code, as well as the Orders 17, Rule 2 of the Civil Procedure Code, in which the Supreme Court has analyzed the Rule 2 as well as the explanation made in the Rule 2. So we can see here is in Order 17, which speaks about adjournment. The contents of this Rule 2 says the procedure if parties fail to appear on date fixed. So when on that date, any date to which the hearing of the suit is adjourned, the parties on any of them fail to appear, the court may proceed to dispose of the suit in one of the modes corrected in the behalf of by Order 9, or make such order as think fit. So the ex parte order was the ex parte order explanation is given there in the Order 9. The Rule 9 says about the Order 9 says about the mode in which the parties fails to appear and the ex parte orders were passed. So this is an explanation is also mentioned here in the Order 9 Rule, Order 17 Rule 2. This is an explanation where evidences or substantial board of evidences of any party has recorded, and such party. So there we can see two parts are there. Any party has been recorded and such parties fails to appear on any date on which the suit is adjourned. The court may, in its discretion, proceed with its case if such party was present. The court has analyzed this explanation and has held in this judgment that this any party corresponds to such party corresponds to that any party which was given an opportunity to leave their evidence but unfortunately could not appear. So this only relates to that party only, not to the opposite side of the party. Let's see what's the contents make out of this judgment. So this is a detailed portion of this judgment is there. Appellant here is the original defendant, number 5, which described as the plaintiff of special suit 125 of 1988. It means civil suit was filed in year 1988, and the appellant here in this case was the defendant number 5, and the suit, the plaintiff was the plaintiff or the respondents here in the special leave petition. So this present appeal assails the correctness of judgment's order dated 2018 passed by the learned single judge of Bombay High Court in civil petition number titled so and so, where the petition was allowed and the order dated passed by the trial court allowed this application under Order 9 Rule 13 was set aside, and ex parte degree was maintained. So if we made an interpretation of this paragraph, this come out that first the ex parte degree was passed. Secondly, after the ex parte degree was passed, this degree was set aside by an application moved by the defendant, and that application, then the trial court has allowed that application. So aggregate from that, the writ petition was filed, and writ petition has set aside then the order which was passed in that application, which allowed the application and set aside the ex parte degree. So after when the verdict of this honorable High Court has passed, the judgment which was passed by this honorable High Court, so then the verdict clearly signifies that the ex parte degree was maintained. So it means the trial court which has passed an ex parte degree, it gets restored by when the application was in which the application of set aside the ex parte degree was passed was set aside by the honorable High Court. So ultimately it leads that the respondents have ultimately got a relief there. So from this it has come out that this made out that shown of unnecessary facts, the respondents filed a special suit number so and so in the code of civil judge senior division, and impleading the as a defendant number 1 and 5 directors. So this signifies that here the respondent which they are impleaded by the appellant, they first filed a civil suit in which they have impleaded the certain some directors, and the appellant is one of the defendant there in that case, and they have made a prayer for 1,42,85,177 rupees with the cost of suit, and for the praying for interest of 18% per annum from the date of the presentation of the suit till realization of the court. That was the prayer which was made in the civil suit filed by the respondent there in that case. So then when now again comes, then the defendant appeared and filed the written statement. Means when the civil suit was filed, the defendant appeared, they filed a written statement, and the court has given a date for their plaintiff evidences. And when the plaintiff evidences stage has come, and then the defendant counsel named so and so withdraw their vakalatnama, and he was not cross-examined not cross-examined the witness. So when the case was fixed for the plaintiff evidences, the defendant counsel had withdraw the vakalatnama, so resulting that the plaintiff witnesses could not be cross-examined. So the trial court on so and so date directed the suit to proceed under Order 7 Rule 2 of CPC that we have discussed. That procedure party fails to appear on that date fixed. So when the counsel have withdrawn their vakalatnama, the plaintiff evidences could not be cross-examined, the plaintiff witness could not be cross-examined, then the trial court proceeded under Order 17 Rule 2 of CPC against the defendant, and they pass an ex parte order in the favor of the plaintiff with the cost. So this is the contents which are reproduced here. Suit is decreed ex parte as with cost. When defendant came to know that ex parte decree was passed against them, they belatedly file an application under Order 9 Rule 13 CPC. This Order 9 Rule 13 CPC says about the setting aside of the ex parte order. This is the Order 9 13 Rule 13 CPC Civil Procedure Code. If ex parte order was passed, so application can to be made in this relevant provision for setting aside the ex parte order, along with the grounds for not appearing on that day. So apart from this, there is a condonation of delay was there. So condonation of delay was under Section 9(5) of Limitation Act. So application was also filed under the Section 5 of the Limitation Act for the delayness. So for condoning the delay, the trial court on that so and so date allowed the application, finding that explanation is to be satisfactory, but some cost was also imposed. Rupees 3,000 was also imposed on the defendants. So trial court. So finally, up to this paragraph, it clearly signifies. It clearly says, first, the trial court has passed an ex parte order. The defendant gets to know that ex parte order was passed against them. Then the defendant filed an application under Order 9, Rule 13 CPC for setting aside the ex parte order. The trial court allowed that application and finding that the grounds are satisfactorily. They allowed that application, but the cost was also imposed against the applicants who was the defendant in that case. So the trial court, while this order allowed this application and set aside the degree, ex parte degree, with imposing fine of rupees 1,000 and restore the civil suit to its original number. So it means finally the destination, they have come to that point where the court has passed the case was fixed for the plaintiff evidences. So civil special suit, civil so and so get restored when the trial court has passed, has set aside its own order, its own ex parte order. So aggravate from this, plaintiff filed a writ petition before the Honorable High Court under Article 227, 226 of the Constitution. The High Court, by its bench order, set aside the order. As a result, respondent MSPEB stood degree ex parte. So means they have filed a writ petition against that order, which set aside the trial court's ex parte degree order. So finally, when the ex parte degree, the High Court has allowed the writ petition, so it granted the relief to the writ petitioner who were the plaintiff in that suit. So ultimately, the suit respondent stood decreed ex parte. Respondent MSCB stood decreed ex parte. So means defendant has got the ex parte order got restored. So the petition was allowed on the grounds that the application under Order 9, Rule 13 CPC would not be maintainable, as High Court has applied the explanation under Order 17, Rule 2 CPC. So this was the grounds which was made by this Honorable High Court in their judgment, that they have applied this explanation. Now, aggravate from this, they filed a special leave petition. The appellant filed a special leave petition. Now, let's see how, after hearing the submissions, the court has analyzed it and made their observation. So, court has said that the submission of the Council of Appellant is that High Court committed a grave error. These were the submissions there. The court has considered their submissions and opposite parties has opposed it. The court has analyzed the sections. Order 17, Rule 2 CPC, which states as follows. So this was the section they have reproduced here in their judgment. And this is the Order 9, Rule 13, setting aside ex parte against the defendant. So the court has said, the plain reading of Order 9, Rule 13 makes it apparent that a decree is passed ex parte against the defendant. A party may apply to court for setting aside for the reasons satisfying the court regarding non-appearance. So, on Order 17, Rule 2 CPC, it's apparent as if parties or any of them fail to appear on that date, the hearing of the suit is adjourned. The court may proceed to dispose in suit in one of the modes in that behalf by Order 9 or such maker order as deemed fit. After analyzing the sections, the provisions of Civil Procedure Code, the court has said, the court has made an observation. The defendant did not appear on that on so and so date 2004, nor the counsel appeared on that date, which has already withdrawn his vakalatnama. The trial court directed for suit to proceed under Order 17, Rule 2 CPC against the defendant. The fact of that order was that the trial court could have proceeded to dispose of the suit in one of the modes and on the behalf by under Order 9 CPC. And since notice was issued, they have filed a written statement also. So now the situation was again revive that the court has said. The procedure adopted by trial courts in that present case, after the evidences of the plaintiff was concluded, the defendant continued to remain absent. The trial court decreed the suit ex parte by judgment so and so date. The operative parts mentioned that suit is ex parte. After analyzing the materials which was placed there on records, the court has held suit was passed and ex parte. The para number 19, which says that now comes to an explanation. What is stated here is that the evidence is of substantial portion of evidence of any party has already been recorded, and such party fails to appear on that day which hearing of suit is adjourned. The court will be at the liberty to proceed the case as if such party was present. So two phrases are important in explanation. Any party, and any party refers to the party which has led the evidence or substantial evidence, and such party refers to very party which has led the evidence or substantial evidence. What is discriminable is that Order 17 Rule 2, the court would proceed to pass order with respect to any of the parties being absent or both the parties being absent. So this is the provision which the court has analyzed. So discriminable portion is that the court will proceed with respect to any of the parties or both the parties were being present, and the explanation is confined to record the presence of any of the party alone, that which has led that and which has led the evidence is a substantial evidence and thereafter failed to appear. In the present case, admittedly the suit was at the stage of plenty evidence that is appeared from this order dated so and so. The evidence of the defendant has not even been started, and the defendant counsel has not even cross-examined the plaintiff evidence. So now the court has made an analysis that only the case was there at this stage of the plaintiff evidences, and the defendant has yet to lead their own evidences. So the court has finally made a conclusion that Honorable High Court has made an error in the making analysis of the explanation 2 of order number 17. The explanation in the present case would have been invoked only if the plaintiff, after reducing his evidence of substantial evidences, failed to appear. The court could have recorded his presence while disposing the suit. But once the defendant has not led any evidence, the explanation would not be invoked as against the defendant appellant. The High Court has committed an error in applying the explanation order 17 Rule 2 CPC. The court has held, the Honorable Supreme Court has held, since the case was there at the stage of the plaintiff evidence and the plaintiff evidence, in case the plaintiff failed to appear, then court could have disposed the matter. But the defendant still have not recorded the evidences, not lead their evidences. So the court has committed an error. The High Court has committed an error in making an interpretation of Order 17 Rule 2. So on the basis of this, the court has held, the Honorable High Court has held that Order 9 Rule 13 CPC would not be maintainable. Application under Order 9 Rule 13 CPC would not be maintainable as the presence of the defendant would deem to be recorded at the time of disposal of the suit. This was the final outcome. They have made an interpretation. So another issue was there that the counsel withdrawn his vakalatnama in normal course. The trial court would have to issue a notice to the defendant to engage in other counsel, which was not done in that case. Since the pleader which was appearing on the behalf of the defendant, he has withdrawn his vakalatnama. But the court, instead of issuing any notices to the defendant, and they have proceeded in ex parte. This court has also made an observation which goes in the favor of the appellant here. So, who was the defendant there at the time before the trial court? The trial court has committed an error in doing so. For the trial court, in its wisdom has and discretion have allowed an application under Order 13 Rule 13, Order 9 Rule 13 CPC. So, court has held that since trial court has committed an error, but later on they have rectified by allowing their application under Order 9 Rule 13 CPC. So, but thereafter, High Court has have to refrain itself from interfering in the order which will advance the cause of injustice, justice by affording opportunity to both the parties so that suit could be decided on the merits. The court has held the High Court need not have to interfere in the application which has set aside the which has set aside the ex parte order by allowing this application there at the trial court. So High Court should not have not to interfere in that, because by referring themselves, they could allow the parties to the case to be decided on the basis of the merits of the case. So for the above, all reasons above, we are unable to uphold the impinged judgment of High Court. The appeal is accordingly allowed. So finally, the court has made their verdict, and so finally outcome was that the suit got restored. So ex parte application, which was allowed by the trial court, set aside by the High Court, the application. The court has interfered in the order of the Honorable High Court. So finally, the suit got restored, and the directions was passed, and the pending application was, if any, stand disposed. So this was a judgment comes in recently passed by the Honorable Supreme Court of India on 16th August 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.